Thank you very much, Vandita, and thank you very much, Kirsty. I hope you can all hear me well. If not, please interrupt me at any point. Thank you for organizing this lecture and for the kind invitation and introduction. I'm very happy and honored to be invited to contribute to this lecture series on law and race, and I'm very much looking forward to our discussion. I will speak to you about the concept of structural discrimination from the perspective of international human rights law, and more specifically from the perspective of one of the core components of the United Nations architecture dedicated to combating racial discrimination, namely the International Convention on the Elimination of All Forms of Racial Discrimination. This convention, the so-called ICERT, is an international human rights treaty, which was concluded in 1965 and entered into force in 1969. This convention does basically two things. First, it establishes legal obligations of the now 182 states parties, obligations to address and to combat racial discrimination. And secondly, it establishes the Committee on the Elimination of Racial Discrimination, the so-called CERT, which is one of the now 10 United Nations human rights treaty bodies mandated to supervise whether states comply with their obligations under the human rights treaties and to make recommendations accordingly. Now, I will not give a general introduction to the ICERT or to the committee, but I will rather focus on the topic of today, that is structural discrimination and the way it is addressed through international human rights law. I will look at this topic through the lens of the Convention Against Racial Discrimination and the practice of the committee. And I'm, of course, more than happy to address and discuss any general or other issues you might be interested in concerning the Convention and the committee in our discussion later on. Let me turn to the phenomenon of structural discrimination. Structural discrimination is quite a difficult concept. There does not seem to be a generally accepted definition of what structural discrimination actually means. It has close links with other concepts, such as institutional discrimination or systemic discrimination. These concepts, structural discrimination, institutional discrimination, and systemic discrimination, seem to overlap, but also to have at least slightly different meanings. At times, however, they are used synonymously. It becomes even more difficult when we ask whether structural discrimination is a legal concept, or more specifically, whether and how it relates to the prohibition of discrimination under international human rights law. Human rights treaty bodies, other United Nations institutions, and even regional human rights courts have at times explicitly referenced the concept of structural discrimination. Academic legal discourse, however, seems to be rather reluctant to fully integrate the concept into the prohibition of discrimination under international human rights law. Structural discrimination is quite often mentioned, but it's not often the subject of more comprehensive analysis. In the next approximately 25 minutes, I can of course not present to you any form of elaborate or sophisticated concept of structural discrimination from a legal perspective. My goal is more modest and basically twofold. It is first to draw your attention to specific entry points in international human rights law, which might be susceptible for addressing aspects of structural discrimination. And it is second to indicate how the concept of structural discrimination can contribute to the understanding of the prohibition of discrimination. In this regard, I will try to show how the concept of structural discrimination can disclose the relationship between different aspects of the prohibition of discrimination. The overall point I'm trying to make is to show that structural discrimination plays an important and quite multifaceted role in international human rights law, and that it is already a well-established concept in the practice of international human rights bodies, even when it's not explicitly mentioned. In line with the specific approach of this lecture series, I will do this with a focus on the prohibition of racial discrimination as it is embedded in the International Convention on the Elimination of All Forms of Racial Discrimination, the ICERT, and applied by the Committee on the Elimination of Racial Discrimination, the CERT. Let me make a few preliminary remarks on the concept of structural discrimination, and let me try, without claiming to be in any way exhaustive, to come up with a definition, or at least with some elements of a definition of structural discrimination. Structural discrimination can, in my view, be characterized by three particular properties. First, structural discrimination has to be distinguished from other concepts of discrimination, which focus on concrete discriminatory acts, utterances, or attitudes. In contrast, structural discrimination is concerned not with singular acts or individuals, but rather with, well, as the name already tells us, structures, in particular, social structures. To quote from a recent article by Professor Shreya Atre in the journal Current Legal Problems, structural discrimination, or structural racism, as she addresses the phenomenon, is, and I quote, embedded not in the minds of individuals, but in the social, economic, cultural, and political forces which define the relationships between people. So what we have is a shift away from individual attitudes and even individual acts to more complex social and economic conditions, practices, and mechanisms, which of course makes it more difficult to address through law and through legal instruments. Secondly, and closely linked, structural discrimination is usually not limited to one specific social field or policy, but it rather takes effect in different fields simultaneously. To quote again Professor Olivier de Schutter from his textbook on international human rights law, structural discrimination cuts across different spheres: education, employment, housing, and in particular access to healthcare, resulting in a situation where the prohibition of discrimination in any of those spheres, or indeed in all of them, will not suffice to ensure effective equality. So again, we have a shift away from specific acts, specific laws or practices, which could be addressed by law and by legal instruments, but rather we have a focus on a diversity of contexts in which discrimination is taking place or finds expression at the same time. And the third, and in my view, very important feature of structural discrimination is that it refers to existing inequalities and disadvantages for specific groups of people, which are oftentimes the product of historical processes such as slavery, racial segregation, or colonialism. Accordingly, structural discrimination is not so much concerned with specific acts, laws, or policies, which in the here and now are actively discriminating against specific groups of people, but rather with the existing conditions, with the status quo as such, which leads to, maintains, and perpetuates disadvantages for certain groups. If we take these elements of structural discrimination together, I think it becomes quite clear why it is difficult to tackle structural discrimination from a legal perspective or to somehow grasp it as a legal concept. Structural discrimination, first and foremost, is a social concept. It refers to social practices and conditions, and not primarily to specific acts or policies which the law could deem to be illegal. It is also not a doctrinal legal concept on par with established concepts such as direct discrimination, indirect discrimination, or positive discrimination. It therefore cannot be seamlessly integrated into the legal framework on the prohibition of discrimination. To say, for example, that the International Convention on the Elimination of All Forms of Racial Discrimination encompasses structural discrimination does not really tell us what that means and what obligations states have under the convention to combat structural discrimination. Such an understanding of structural discrimination as a distinct legal concept or even as a doctrinal legal figure obscures the fact that structural discrimination cannot be addressed as such, but only in connection with other established doctrinal forms of discrimination, such as direct or indirect discrimination or positive measures such as affirmative action. With these preliminary remarks in mind, let me now turn to three specific instances in which the phenomenon of structural discrimination can play a role in the law against discrimination, in particular racial discrimination under the I-cert and in the practice of the cert. First, I will look at the prohibition of direct discrimination, and I will try to show how the consideration of structural discrimination can contribute to our understanding of instances of direct discrimination and of the measures necessary to effectively combat and prevent such discrimination. Secondly, I will turn to the duty to protect that is the positive obligation of states to take measures to prevent and combat discrimination, in particular between private actors. In this regard, I will try to show how the concept of structural discrimination can help to identify areas in which the state needs to act and thereby contribute to the elimination of discrimination and discriminatory structures. And thirdly, I will analyze how the Convention addresses discriminatory structures more directly through 3 distinct provisions, which taken together make a very strong case that states are obliged to not only combat discriminatory acts and practices, but also to address discriminatory conditions and existing disadvantages going beyond. Let me start with the most basic and uncontroversial form of discrimination under the prohibition of discrimination, that is direct discrimination. Pretty much every legal framework that deals with discrimination encompasses a prohibition of direct discrimination. Direct discrimination occurs when a distinction is more or less explicitly based on specific categories which are encompassed by the prohibition of discrimination. In the case of racial discrimination, primarily race, a category which, due to the non-existence of different human races, I like to put in quotation marks, ethnic origin, or any proxy such as skin color. A person or a group of persons is treated differently than others because of his or her actual or assumed belonging to a racial or ethnic group. A much discussed example of direct discrimination is racial profiling in law enforcement. When the police specifically targets people based on race, color, or ethnicity in seemingly arbitrary stops, searches or identity checks, this constitutes direct discrimination and falls within the scope of the prohibition of racial discrimination. Legally speaking, racial profiling is a pretty straightforward case of direct discrimination, which is prohibited and which in principle cannot be justified. So what additional value could it have to look at racial profiling from the perspective of structural discrimination? I think there are 2 points worth mentioning. First, taking into account the structural dimension of racial profiling will disclose the full impact of such seemingly random checks and searches for the person subjected to them. If viewed as an isolated practice or incident, such identity checks might seem rather harmless. After all, a person is only asked to identify themselves, usually no further police measures are taken, and the check regularly does not last longer than a minute or 2. As a consequence, domestic courts, at least in Germany, oftentimes do not take such incidents of racial profiling too seriously. They rather highlight that the degree of interference with the rights of a person who is subjected to an identity check is low. By contrast, the structural dimension of discrimination puts a spotlight on the stigmatizing effects of such seemingly low-intensity interferences. It draws our attention to the impact such discriminatory acts have for people who are vulnerable to discrimination and who experience discrimination on a regular basis. It highlights the wider implications of discriminatory controls for the level of trust that people of color have in state institutions and in the judicial system in particular. The full extent of the human rights dimension of incidents of racial profiling becomes apparent only when we regard them not as isolated incidents of direct discrimination, but as part of and as embedded in wider structures of discriminatory practices and attitudes. This wider perspective can be of relevance when courts decide cases of racial profiling, for example, when it comes to the burden of proof or with regard to the award of damages. Secondly, a focus on the structural dimension of discrimination will guide us on how to actually address the phenomenon of racial profiling. It is not enough to simply point out that racial profiling is prohibited and to expect law enforcement officials not to engage in racial profiling. From a structural perspective, both the causes of racial profiling as well as the remedies against racial profiling appear more complex. In this regard, the Committee on the Elimination of Racial Discrimination has, for example, pointed out different possible causes for racial profiling, including the impact of implicit biases and of unconsciously held stereotypes shared among society in general, and therefore also among law enforcement personnel, the lack of understanding and the lack of empathy for people who are subjected to racial discrimination, and a lack of diversity in law enforcement and the absence of a culture of interaction and communication with communities which are specifically affected by racial profiling or by other forms of racial discrimination. The structural dimension of a discriminatory practice can thereby highlight possible measures which can or which should be taken to effectively combat practices such as racial profiling. From a legal perspective, the prohibition to engage in acts which constitute direct discrimination is thereby complemented by an obligation to take effective measures to ensure that the prohibition of racial discrimination is complied with. The concept of structural discrimination thereby enriches our understanding of direct discrimination. Let me turn to a second example, the duty to protect. Under the International Convention on the Elimination of All Forms of Racial Discrimination, states not only have the obligation not to engage in discriminatory acts, but they also have the duty to protect members of vulnerable groups from acts of discrimination. States must take active measures in order to prevent racial discrimination, and they must react to instances of racial discrimination once they occur. The structural dimension of discrimination plays an important role in this context. On the one hand, systematic instances of discrimination and widespread discriminatory practices can activate the duty to protect. Awareness of structures of discrimination is important in order to be able to identify areas in which the state needs to actively intervene to protect members of vulnerable groups from discrimination. On the other hand, measures taken to implement the duty to protect can aim at improving the overall situation and at changing the structures which facilitate or support discriminatory behavior. Take the example of racist hate speech. Under the convention, Article 4 of the convention to be specific, states have the duty to not engage in hate speech, and they have the duty to combat racist hate speech within society. In this regard, the committee highlights that states not only have the duty to make racist hate speech a punishable offense, but that they also must take active measures to combat hateful stereotypes which persist in society. And states need to take initiatives aimed at, for example, making education more sensitive to issues of discrimination, or at avoiding the use of harmful stereotypes or the dissemination of hurtful messages in the media. The existence of structural discrimination as a social phenomenon therefore triggers the duty to protect, an established obligation under international human rights law. And awareness for those structural factors contributing to discrimination sensitizes us for measures aimed at the conditions and root causes of discriminatory practices. My third and final example concerns provisions in the convention which in a more direct manner address existing structures of discrimination. The concept of structural discrimination can provide a link between these provisions and can be understood as the foundation for the practice of the committee, which regularly addresses the structural dimension of racial discrimination. The convention addresses existing structures of discrimination in particular in three instances. Article 3 of the convention states in a rather performative manner that states parties condemn racial segregation and apartheid. Article 3, moreover, obliges states to eradicate such practices of apartheid and of racial segregation. While the concept of apartheid has not played a too significant role in the practice of the committee, segregation along racial lines is very much at the center of the committee's attention. The committee is regularly concerned by findings of segregation with regard to, for example, housing, education, or employment. Such findings are then regularly analyzed through the lens of a second provision, Article 5. Article 5 of the Convention addresses racial discrimination in connection with the enjoyment of other human rights guarantees. Beyond classical civil and political rights, Article 5 also refers to economic, social, and cultural rights, such as the right to work, the right to housing, the right to education, the right to health, and the right to social security and social services. Now, the Convention does not guarantee these economic, social, and cultural rights as such, but obliges the state parties to not discriminate in the context of these rights and to address discrimination when it occurs in the sectors touched upon by these rights. On this basis, the committee regularly demands information and scrutinizes the degree of equality of specific groups, in particular with regard to employment, housing, education, health, and social services. The existence of detectable inequalities along racial or ethnic lines is then taken as an indicator for structural disadvantages which need to be addressed and which need to be combated by the state. In this context, a third set of provisions of the Convention gains relevance. Article 1, paragraph 4 and Article 2, paragraph 2 specifically provide for so-called special measures. That means affirmative action for the benefit of members of particular disadvantaged groups. The Convention makes clear that such special measures do not constitute discrimination. And under certain circumstances, states are not only allowed, but they are obliged to take such measures in order to ensure the adequate development and protection of certain racial groups. The Convention thereby acknowledges the significance of existing disadvantages and requires states parties to effectively address them. Dear colleagues, I've tried to give you an impression of the way in which the International Convention on the Elimination of All Forms of Racial Discrimination and the practice of the Committee on the Elimination of Racial Discrimination incorporate the concept of structural discrimination into the system of the prohibition of racial discrimination. The committee has built upon the approach of the Convention and regularly addresses the structural dimension of racial discrimination in specific thematic contexts, such as the criminal justice system, racial profiling and law enforcement, or in particular economic and social contexts. The committee has moreover addressed the structural dimension of discrimination of specific racial or ethnic groups, most notably people of African descent, indigenous peoples, members of the Roma community, as well as non-citizens, refugees, and asylum seekers. Let me end with a quick outlook on the further potential of the concept of structural discrimination. As I've mentioned at the beginning, structural discrimination is concerned with existing disadvantages and with patterns of discrimination which work to the detriment of specific groups and of their members. Most often, however, such existing structures are the product and the legacy of historical practices of injustice, such as slavery and colonialism. International human rights law has quite cautiously begun to address this relationship between the past and the present. And I'd like to just give you a couple of examples. The Durban Declaration and Program of Action adopted at the World Conference Against Racism in 2001, for example, explicitly links the injustices of the past with existing forms of racism and racial discrimination. And the United Nations Human Rights Council in October 2021 adopted a resolution on the negative impact of the legacies of colonialism on the enjoyment of human rights. The Human Rights Council thereby also establishes a clear link between past practices of colonialism and the existing impairment in the enjoyment of human rights, in particular for people of African descent, people of Asian descent, and for indigenous peoples. International human rights law thereby provides a normative framework for addressing the possibility of redress for injustices of the past, not necessarily because they were illegal or morally wrong at the time or in hindsight, but because they continue to have a negative impact on specific groups of people in the present. The Committee on the Elimination of Racial Discrimination has built upon this idea in different ways. With regard to the rights of indigenous peoples, the committee regularly addresses the question of respect for traditional land rights and the issue of the return of territory from the state to indigenous communities, or at least compensation for the taking of land. And in the most recent state party review concerning the United States of America, conducted in August this year, The committee extensively addressed the issue of redress for legacies of the past. In doing so, the committee took up discussions within the United States of America concerning the continuing impact of slavery on people of African descent. In this context, the committee explicitly addressed the issue of reparations for slavery. Leaving aside the question of whether a legal obligation to provide for reparations for the continuing impact of past injustices exists, international human rights law is not silent and is not indifferent towards this question, and will continue to be an important normative point of reference for discussions of how to address this historical dimension of structural discrimination through reparations and beyond. I thank you very much for your attention, and I'm looking very much forward to our discussion.